Okay, so fact-finding hearings. They're also called re-el hearings or sometimes finding of facts. Now, these hearings are ordered when a court wants to examine the allegations that people have made in the family courts. Now, I'm always saying that if you're accused of something that didn't happen, you say it didn't happen, you refute the allegations and you move on. But when it comes to a fact-finding hearing, that is the time that you need to get the evidence out. So if you're saying that you had evidence and it wasn't looked at, this is absolutely the kind of hearing that you are going to want to put evidence to demonstrate that something did or didn't happen. So typically what will happen is one party will make allegations, sometimes both, and the court will say, okay, we're going to ask you to produce something called a Scott schedule with perhaps 5, 6, 7 or another number of allegations on it. So you pick the most extreme examples, and the Scott schedule is like a spreadsheet. So you've got the allegation, when it happens, and the effects on the people involved, the children involved. And then what happens is it gets submitted to the court, and the court will order a hearing to go through those allegations. Now, there will be cross-examinations, there will be a trial bundle, or there should be, with all the evidence to demonstrate that something did or didn't happen. Worth remembering as well that this is not a criminal court, so it's not a case of people being found guilty or innocent. Facts will either be found or not found. In a criminal court, the burden of proof is beyond reasonable doubt. In a family court, it's on the balance of probabilities. That's why if a fact is found, the judge will say something along the lines of, I find it more likely that this did happen than didn't. He's not saying you're guilty, he's not saying it did happen, he's saying he thinks it's more likely it did happen than didn't. Lower burden of proof. So what's the upshot of a finding of facts hearing? Well, it can depend. If facts are found against you, it's important that you accept the findings against you. Now, you can, till doomsday, say it didn't happen, the court's rubbish, and if the court, for example, finds that you've, done something that involves domestic abuse, for example, and you don't accept it, and the court recommends that you attend the perpetrator's course and you refuse to accept it because it didn't happen, that can hold your case up. After a finding of fact hearing, the court will provide recommendations in a subsequent hearing about what's going to happen. It might be that you attend the course. It might be they want you to do anger management. It might be that you want parenting courses, that sort of thing. A finding of facts hearing, a fact-finding hearing holds things up. Your case regarding contact or what happens with the children will be put on hold until these allegations have been investigated and a court has made a decision on them. So the best thing you can do is to actually engage with the process, accept the findings, and act on them and work with the court. You can refuse a course, but if you do that, you may find that your course is stuck until you do so. So yeah, that's the nuts and bolts of it. It's a little bit more complicated than that, as always, but that's the bare bones of it.